I'll hand you over to Sal Jenkins. Thanks very much.
Thanks, Tom. Hi, everyone. I'm Sal Jenkins, Principal Business Development Manager at Freeths. I hope you're all well, and thank you for joining us this morning. On behalf of Freeths, I'd like to welcome you to the first of our 6 Brexit Brunch Week seminars. And we're privileged today to have on our panel experts from Freeths, including Simon Barker, Partner, Head of Intellectual Property, Lindsey Clegg, Partner, Dispute Management, Luke Dixon, Partner, Head of Data Protection, and Emma Brooksbank, Partner, Head of Immigration, and Iain Bowler, Partner, Head of Commercial. I'll be passing over to the panel shortly for their presentations, but before I do, I just wanted to remind you, as Tom said, there will be an opportunity to submit questions during the presentation, although many have been submitted beforehand, and we'll try to get through as many as we can today. Those we can't answer, we will respond to offline directly with you in the next few days. Now I'm passed to hand over to Iain Bowler, who will kick us off on protecting your business post-Brexit.
Thank you, Sal. Good morning, everybody. Brexit and the coronavirus pandemic has brought supply chain resilience to the top of the worry list for many people, particularly those who consolidated their supply chain into a small number of suppliers located either in China or in the Far East. As a result, many businesses are now scrambling to shorten supply chains and to diversify their supplier base, and delays at UK borders as a result of Brexit has been a further disruptor. Add to this uncertainty over cost increases resulting from additional customs compliance and the effect of adverse currency fluctuations, and you have the perfect storm, where you may be unable to supply your own customers while at the same time having to absorb cost increases which impact profit margins. So what does the post-Brexit trading environment look like, and what opportunities are there? So to answer this question, we need to look at the Trade and Cooperation Agreement, a 1,200-page contract incorporated into UK law on the 30th of December 2020 by the European Union Future Relationship Act. Now, in this section, I'm only going to touch on one element of that agreement, and that's the free trade deal. So although it's no match for the level of economic integration that existed whilst the UK was an EU member state, the free trade deal creates a zero tariff, zero quotas regime for many products, and is a significant improvement over the WTO position that would have existed had the Trade and Cooperation Agreement not been put in place. However, the free trade deal only applies to products that comply with the rules of origin, which is itself an extremely complex set of provisions that take up about 50 pages of the Trade and Cooperation Agreement. And if your products don't meet the rules of origin, then you will probably still fall back onto the WTO rules. The Trade and Cooperation Agreement also provides a basis for simplified customs checks at UK borders. However, the rules at this stage are quite vague, and there are customs checks being applied to all products, which is causing delay and disruption in the supply chain, although the level of disruption does seem to be calming down a little bit now. It's also worth noting that there are different rules for Northern Ireland. For products moving from Northern Ireland to Great Britain, there are no new customs procedures. Though note that there are provisions that prevent EU businesses from using Northern Ireland as a channel to place goods on the British market. For the supply of products to Northern Ireland from Great Britain, a customs declaration is now going to be required. So how can we minimise risk when trading internationally? Well, there are a number of things we can do. The first of which is to look at the procurement processes, looking at where you are, looking at where you're sourcing raw materials and components from to try to avoid or reduce the impact of increased costs and delays. This really is about putting contingency plans in place, and where justified, building some level of redundancy into the supply chain. Diversifying the supplier base involves placing less reliance on a small number, sometimes of exclusive suppliers, and increasing the geographic spread of suppliers can also help reduce the impact of particular region or country-specific lockdown restrictions, which may limit or cut off your source of supply. Another thing that you should be looking at is renegotiating existing contracts or building risk mitigations into new contracts that you enter into, and I'll be passing on in a few minutes to Lindsey Clegg, who'll be talking about this in more detail. So, in summary, what should we be doing now? Well, I think the answer to that is planning and provisioning. There's so much that there is no such thing as a risk-resilient supply chain, in my opinion. But you can use each disruption that comes along, whether it's Brexit, whether it's the coronavirus pandemic, as a learning experience to help you respond in an agile fashion and figure out durable solutions for the future. So having said that, I don't believe there is such thing as a risk-resilient supply chain. What can you do to protect your business? Well, for lawyers, you won't be surprised to hear it all comes down to risk and what you can do to either eliminate, mitigate, or manage those risks. And this essentially means making the supply chain as robust as possible. So how can we do that? Well, as I've already mentioned, putting in place contingencies, building in redundancy, reduce dependency on a small number of suppliers or on exclusive suppliers. Look at creating a more diverse supplier base geographically. Balance the cost of potentially more expensive but more robust supply chain solutions against your operating margins. And also, I think, consider new ways of working. I mean, do we have to continue to work in the future like we have done in the past? And what technology might there be to help you de-risk the supply chain in the future? I think one of the most likely disruptors in the next 12 months will be supplier insolvency. There are lots of warning signs out there that a key supplier may be in financial distress or heading that way, but you need to be looking for them. These include market rumours, deteriorating service levels, changes in the management team at the supplier organisation, unsatisfied court judgments, suppliers stretching payment terms or seeking to renegotiate payment terms or requesting payment on a pro forma basis or requesting deposits, delayed deliveries, late filing of information and accounts at Companies House, and unqualified audit reports in statutory accounts. All of these can give you an indication that your supplier may be in financial distress. So I think do what you can to set up monitoring processes. Usually that's through having good contract management provisions in your contracts, and then ensure that you police those monitoring processes. I think one of the other things that you can do to try and ensure that your supply chain is robust is communicate with your key suppliers. You might be amazed how many businesses don't communicate with supply chain unless things start to go wrong, at which point it can often be too late. I mean, you wouldn't dream of not communicating with your customers, but your suppliers are just as critical as your customers. So try to create a congruent approach with your key suppliers to help avoid, prepare for, and mitigate the effects of future disruption. And some of the things that you can also do is to include in your commercial contracts certain commercial levers, key performance indicators, service level agreements, service credits regimes. As I've mentioned, effective contract management and governance procedures, sometimes including supplier self-reporting of delivery and service failures, and effective remediation and improvement processes. Delay payments or liquidated damages. A required reference clause. Don't see this very often, but where a supplier is pitching for new work in the future, a requirement in your contract that it has to use you as a customer referee for that new work, which provides a certain incentive for the supplier to look after you and keep you happy. A requirement for periodic financial information reporting. A requirement for self-certification of certain minimum financial covenant tests, for example, the acid test or the current ratio, minimum net worth, etc. Audit rights in your contracts and delivery of audited or management accounts. So lots that you can do in order to create early warnings. And then finally, a word about contingency planning, again, through your contracts. If the contract justifies it, include a requirement for the supplier to provide you with a business continuity plan or a disaster recovery plan. This helps to create that congruent approach between you and your supplier and an agreed plan of action for what for what to do if the worst happens. So I think that's probably my time up. I'll pass over to Lindsey to talk to you about contracting risks and avoiding disputes. Thank you.
Thank you, Iain, and good morning, everybody. Brexit has introduced a huge amount of uncertainty for business over the past few years. Now that we have the Trade and Cooperation Agreement in place, businesses should be in a more informed position to prepare their customer and supplier relationships to mitigate the impact of the perhaps inevitable disruption, uncertainty as we all transition to a completely new way of working with our parties in the European Union. There have been very few changes, fortunately, to the law itself, certainly at this stage. The vast majority of applicable EU law became EU retained law and was transposed over into our own domestic legislation. But over the longer term, changes and divergence from the position adopted across the European Union is probably inevitable. However, difficulties do remain in assessing the cost and effort involved in doing business with partners across the EU and how best to manage that in your contracts. On Thursday, Jessica Brickley from our commercial team will take you through how the contractual landscape is changing following the end of the transition period and how you can navigate those changes and ensure that your contracts are and remain fit for purpose. Amongst other topics, Jessica will look at contractual mechanisms for allocating risk and responsibility and for mitigating the impact of potential future uncertainty. For instance, how will any increased costs of doing business as a result of Brexit be dealt with? Who bears the additional costs of getting goods out of the country? Not just customs duties, but the cost and the time and the effort actually involved in physically doing that. If your contract is silent on this and you are a party supplying a counterparty in the European Union, then you are likely to be the party responsible for any new or increased costs that are incurred. And you're also likely to be the party who is responsible ultimately for any delays, unless your contract is on a time and materials basis or only requires you to actually get the goods to or just outside the export port, which is quite rare in practice. And what happens if your contracts are and your arrangements are no longer commercially viable or need to be altered? Might there be a mechanism within your contract to get out of the contract or to change the terms to make them more favourable to you? And is there any prospect of exiting an unprofitable contract purely because of Brexit? Sadly, the answer to that is likely to be no, unless there's something specific to Brexit that has made it either illegal or impossible to physically perform your contract following the end of the transition period. We'll also look at how you might deal with this to protect your own position and also protect your position with vital suppliers, customers and partners. And then on Thursday, during our brunch slot, I will look at how Brexit impacts what happens when something goes wrong with a relationship with a counterparty in the European Union. Will you still be able to enforce your contract when your counterparty or its assets are located in the European Union? Whose law will govern those contracts? Where will your disputes be heard? Will they be in your own local court or will they be heard in the place where your supplier, your customer, your joint venture partner is located themselves? Will you be able to expressly choose things in your contract and put a written term in place that sets this out, as we could do before? And if you choose these things in your contract and you've chosen them in a contract which predated the end of the transition period, will they still be respected and upheld in the English courts or in the courts of other European Union member states? Unfortunately, the Trade and Cooperation Agreement that was entered into on the 24th of December made no long-term provision for jurisdiction. That is where any claim or dispute between two parties should be heard, or the enforcement of court judgments between the UK and the EU following the end of the transition period. I will take you through how the landscape has now changed in relation to contracts, their enforcement and disputes arising under them, where one party is based in the UK and the other or its assets are based in a EU member state. What I can say, unfortunately, and with some degree of conviction, is that dispute resolution involving someone else in the EU is likely to become more complex. It's going to be more time consuming and more expensive than it was before. And there will be an increased need both for specialist litigation advice from people with cross-border experience and also potentially from local lawyers within the jurisdiction where your counterparty or its assets are based. None of this is particularly good news, I'm afraid, but we will take you through the practical steps you can take to minimise the risks involved and put yourself in the best position going forward. I will also look at arbitration. For anyone who's not familiar with what arbitration is, it's an alternative to using the courts to resolve your disputes. Arbitration and the enforcement of arbitral awards, which are the arbitration equivalent of a High Court judgment, is completely unaffected by Brexit. Might this provide you with a safe harbour which avoids the increased risk, uncertainty and cost of that will now be involved in court litigation against somebody based in the EU? We will talk through that and discuss the pros and cons. in summary, when you're putting in place contracts with people in the EU, think ahead, look at what you might need to take, the action you might need to take if somebody acts in contravention of your contract, if something goes wrong, and then tailor back, look back, and make your ensure that's possible, and make the contractual provisions fit to ensure you can do that, and also make sure that your contract is worth the paper that it is written on. And if things do start to go wrong with a relationship, step back and think. Many people will immediately call their lawyers. They'll want their lawyers to write an aggressive letter. But do you need to work with that partner? How vital is that relationship? Is it business critical now to get you through the next 6 months? Is it business critical for the next year, for the long-term plans of your relationship? Do you need to get on the telephone to your supplier and try and work out a new way of working that works for both of you and gets you through this difficult period? And if so, how should you deal with that? How should you document it? How should you make sure you're protected? Or is this the sort of scenario where you do actually need to step in and take formal action to protect your position? I will now hand you over to Luke Dixon, who heads up our data protection team at Freeths, and Luke will be talking to you about the data implications of the end of the transition period for businesses.
Thanks very much, Lindsay. Good morning, everybody. I'm here this morning to talk about the data protection implications now of the end of the transition period and the new arrangements going forward. I think it's very much a case of sort of tension, if you like, between us remaining aligned on data protection issues with the remaining EU 27 member states, but on the other hand, of course, going forward, sort of striking out on our own and being outside the EU and a third country. So I think that the issues that your businesses will be facing will be wanted to have to address this alignment on one hand, but also this sort of distancing of ourselves from Europe on the European Union on the other hand. Now, this morning's purposes, I'll just be talking at a very high level about the following topics. I'll be talking about them in more detail in my session tomorrow, because like with all things GDPR, they are quite tricky and they probably don't lend themselves to a 5-minute summary now. But the issues I'll be talking about are where we are generally under the TCA in terms of our relationship with the European Union and data protection compliance. Another thing I'll be talking about is a very hot topic, and probably the main topic, I think, really is data transfers between the EU and the UK. That's the very important aspect of, commercially speaking, of flow of personal data between us and the EU, where we are and where we should be going as well, and also talking about elements of us, sort of the consequences of us now being a third country, in particular things like whether you need to appoint an EU representative now longer that we're no longer part of the EU on the one hand, also maybe having to select an EU lead supervisory authority as well to deal with data breach issues in particular, for instance. So taking those issues in turn, firstly, where are we generally? Well, under the Trading Cooperation Agreement, the TCA, it doesn't actually say all that much about data protection. What it does have, though, is a general statement that the UK and the EU remain committed to pursuing high data protection standards. And this suggests to me, and I think to other commentators, that we will remain quite aligned for the time being to GDPR and EU data protection standards. And to that end, we've actually incorporated GDPR into our legislation now as UK GDPR, very imaginatively named, but it does the job. And that legislation will sit beside the UK Data Protection Act 2018, which we've had for the last few years since original GDPR came in. So businesses that process data cross-border will be operating under the UK GDPR regime and the EU GDPR regime. Truth be told, for the time being, not a lot of difference between the two. So that's quite good from that perspective. Now, I think one of the key reasons why we're looking to remain aligned is in order to secure what we call an adequacy decision. So, okay, we're a third country now outside the EU. That means technically, a lot of third countries aren't allowed to receive data transfers from the EU, but if we remain closely aligned, it increases our chances of being regarded as adequate by the EU to therefore continue to receive free flows of data from the EU. And the last thing that the TCA talks about is a sort of a mutual shared protection or continuation of protection of individuals in relation to unsolicited marketing. So, we've been sort of a part of the EU legislation for a number of years. The privacy legislation has placed certain restrictions on the ability of marketers to send unsolicited direct marketing to their customers and to individuals. And it looks like we are going to continue to maintain similar standards to the EU in relation to that as well. So that might have implications for future legislation that's coming off the ramp at some stage in the next few years. So talking now about the data transfers, and this is really the main issue we get most instructions and queries about from businesses. So just a quick recap on where we are with GDPR. GDPR has always said or placed a sort of first instance ban on data transfers of personal data outside the EU to most third countries. And the reason why it does that is the EU deems the local laws in third countries to be a lower standard than GDPR for protecting personal data. So it was all well and good for us once we're still part of the EU. We got free flows of personal data. And that continued throughout the transition period. So, okay, the transition period's over. What's happened now? Can I still receive data free flowing from the EU into my business in the UK? Short answer is short term, yes, because we're actually going through a grace period, which is due to end in June of this year. And that grace period permits continuation of free flow of data from the EU to the UK. And the reason why this grace period has been introduced is to enable the EU to determine whether it's going to deem us to be an adequate country to continue to receive free flows of data. And I can reveal that hot off the press on Friday, the EU issued a draft decision in favour of granting us adequacy. So we're not quite there yet, but things are looking good. So I think that the longer term view over the next few years is it's looking far more likely than not that those free flows will continue, which is great. But we're not quite out of the woods yet. In terms of flows from the UK to the EU, it's been the UK government's position pretty much since within a couple of weeks after the EU referendum on Brexit that those flows should continue. So that's not going to be an issue. And then the next point, in addition to that, is because we're a third country, we're no longer sort of part of the EU mechanics and infrastructure for data protection. Your business might have to deal with issues around, firstly, appointing an EU representative, and secondly, deciding whether it needs to appoint a lead EU supervisory authority, or basically data regulator to which you have to report issues or you have to deal with. Briefly looking at the EU representative first, that's basically a representative. It could be a person or an organisation who basically is within the EU, who you appoint to be really a touch point for data subjects and data regulators in the EU, just in case there are any issues with regards to your data processing in the EU. And you have to basically appoint an EU representative if you undertake cross-border data processing, but you are not established in the EU. The second point is in relation to EU lead supervisory authorities. So in the past, the UK ICO was a supervisory authority under the EU's data protection infrastructure. Of course, now because we're a third country, it can't be part of that infrastructure. So if you have issues with your data processing in the EU and with it in the UK, you'll have to separately report to or deal with the UK ICO on the one hand, but also potentially an EU regulator or EU regulators in the EU in relation to the EU aspects of that. Now, I'm not going to go into the rules around whether you need to appoint a lead supervisory authority in the EU and here because it's quite complicated, but if you can do so, it's beneficial to do so, because that lead supervisory authority will be the main touch point for you in relation to EU issues. So you won't necessarily have to deal with multiple EU data regulators, which could make things a real administrative headache. So another thing that your business needs to consider is, do we need to appoint one? Are we in a position to choose, and how do we go about choosing that? So I'll be talking about those issues as well in more detail tomorrow. So I think overall, the issues to consider are, monitoring and thinking about where we are in terms of alignment and what that means going forward in terms of data protection compliance if you process data cross-border between the EU and the UK. Data transfers, keeping a very close eye now on the admittedly promising developments in that area, what your businesses should be doing, if anything, maybe to contingency plan, etc., and to really take a risk-based approach on that. And also, consider where your business sits in relation to whether it needs to appoint an EU representative, or whether it needs to appoint an EU lead supervisory authority if it is in the position to do so, and how it would relate or coordinate itself in relation to UK ICO regulatory actions and those of the UK authorities as well. And that's on top of other sort of, I suppose, more housekeeping, less glamorous points that I'll be discussing as well, around updating your privacy notices to take account of things, the fact they'll be under UK GDPR, whether your data protection officer appointments should now straddle UK and EU, and then the things like, if you have binding corporate rules, whether you'll need to update or deal with issues in relation to those as well. So I hope that's been a useful high-level insight into where we are and where we might be going on the data protection front. And I look forward to discussing these points with you in more detail tomorrow morning's session. I'm now going to pass on to Simon Barker, who heads up our IP team. And Simon will be discussing the intellectual property issues in relation to this overall matter.
Thank you, Luke, and good morning, everybody. So I'm going to cover briefly the impact of Brexit on IP, and particular issues relating to trademarks, designs, geographical indications, issues around parallel imports, and a quick note on customs seizure. These and more will be covered in more detail in the IP-specific webinar, which is scheduled for next Monday at the same time. So starting with trademarks, the main impact has been in relation to, unsurprisingly, EU trademark registrations, which on the 1st of January 2021 no longer afforded protection for trademark owners in the UK. However, the good news is that the UK government decided to preserve those rights by creating equivalent UK rights with all the same filing dates, the same goods and services specifications for the UK, effectively cloning the EU rights in the UK. This has been at no cost and has obviously been quite welcomed by trademark owners, and of course it means that no rights will be lost. There is an exception for pending EU applications, which are subject to payment of a UK application fee, but there's 9 months in which to do that, and essentially it preserves the priority date. So again, no rights lost in respect of pending applications either. Less good is that going forward, of course, that will mean one needs to apply separately for UK coverage and EU coverage at what is a net additional cost. There will also be a net additional cost on renewal because, of course, they'll have to be these trademark rights will have to be renewed separately as well. The other thing to note, which we'll go into more detail on the detailed seminar, is that of course trademarks are vulnerable to revocation if you don't use them for 5 years, whereas use in the UK would have counted towards use of an EU mark previously. Now it won't, and so trademark holders will have to ensure both use in the EU and the UK if they want to preserve their rights in the longer term. The position with designs is similar in that registered community designs are cloned in the same way as EU trademarks, making them effectively registered as UK registered designs. So again, it's good news in that no rights will be lost to proprietors of registered community designs, but again, going forward, applicants will need to consider whether they want to apply separately. And of course, they too will be subject to separate renewals, which in the case of designs is every 5 years. So potentially additional costs there. There are changes to protection of the unregistered designs, and whereas during membership of the EU, there was opportunity of protection under community unregistered designs. At the time of Brexit, these will continue to be protected as continuing unregistered designs in the UK. So a similar kind of approach to that which we've seen in relation to trademarks and registered designs. And going forward, the UK government has implemented what is called a supplementary unregistered design, which will effectively cover what the community unregistered design would have covered before. So it effectively mimics it. We will be covering designs and the wider impact on the changes next week, particularly in relation to unregistered designs and perhaps some of the things that you might need to think about if designs are important to your business. The next thing on the list of things to briefly mention are geographical indications. GIs are used on products that have a specific geographical origin and possess qualities or reputation that's attributable to a particular geographical area. They generally apply to foodstuffs, wine, spirits, things like Scotch whisky and Melton Mowbray pork pies will be familiar to everybody, I suspect. You're used to seeing the red and yellow EU story logos on blocks of Stilton and the like in the supermarket. Well, there's a new scheme of geographical indications for the UK, which will be administered by DEFRA, and new black and white logos for GIs here too. So we'll start to see those in our supermarkets. They look a bit like a 20p coin. Once again, a similar approach to trademarks designs. Previously, GIs were registered with the EU Commission. Those GIs will continue to be protected in the UK and have been cloned in the same way. That is, if they were in place before the 1st of January 2021. Goods, in terms of marking, I think Iain alluded to the distinction between Northern Ireland. Goods to be sold in the EU and Northern Ireland will have the EU marks applied to them, and in England, Scotland and Wales, the UK ones. You can have both if you sell goods in both territories. There won't be a requirement to label goods with the new UK ones until January 2024. The next point that I briefly wanted to mention was the question of parallel imports and exhaustion of rights. Most people would be familiar with the concept of parallel imports or grey goods and the concept of exhaustion, which describes the principle that an IP owner cannot object to the resale of goods in another territory to the one in which the goods are first sold by them or with their consent, i.e. the rights are exhausted after the first sale. The EU's rules on free movement of goods, of course, won't apply in the UK anymore, and so on Brexit, exhaustion is not automatic in the EU. The Trade and Cooperation Agreement that we've heard a lot about this morning essentially left it open for the EU and the UK to determine for themselves whether exhaustion of rights will apply between goods imported and exported from and to the EEA. The UK government has provided that following Brexit, there will be no change, so that the sale of goods on the market in the EEA will be exhausted in the UK. However, there is no reciprocity at the moment for goods put on the market in the EEA. So UK rights holders can't prevent parallel imports from the EEA, but owners of IP rights in the EEA can prevent parallel imports from the UK. The principles apply to registered designs, to trademarks, to copyright and to patents. And practically what this means is that if your supply arrangements involve reselling into the EEA, you'll need to ensure consent from the rights holder if you want to ensure the goods aren't stocked when arriving in the EEA. Finally, following on from that, a brief note on customs seizures and applications for action by UK border forces. IP rights holders can no longer apply for action be taken by UK border forces at an EU level, which means that if you distribute branded goods, for example, that are vulnerable to counterfeiters, then you'll want to review whether you have the right process in place. That's because an EU application for action applied for via the EU prior to the end of the transition period will no longer be effective in the UK, and a new UK application for action will be required there. Also, conversely, an application for action applied for via the UK to cover the EU will no longer cover the EU, and a separate EU application will be required. And so, if this is an area that's applicable to you, it's probably worth just checking whether or not you have the right application for action in place for your business. We'll be talking about all of these things and some more in the more detailed webinar due on the 1st of March, and look forward to discussing those things then. I'm now going to hand over to Emma Brooksbank, who leads on our immigration issues. She is going to talk to you about, Emma's going to talk to you about the specific, in particular, businesses that employ EU nationals. Over to you, Emma.
Brilliant, thanks Simon, and good morning everybody. So yeah, in this session I'm really just going to look at the headlines for any businesses and organisations who employ European nationals who might be planning to recruit from overseas, including from Europe in the coming year. So the top of the bill, biggest headline is that the UK immigration system has changed. It changed on the 1st of December for what we'd call rest of the world nationals, so for non-European nationals. But then as we got to the end of the transition period and as free movement came to an end, the new immigration system that we have now then applied to European nationals, so from the 1st of January 2021. And the real sort of fundamental principle of the new immigration system is that there is no preferential treatment for European nationals. So the whole system applies equally to European nationals as it does to nationals from the rest of the world, which is of course a fundamental change compared to what came before, which was free movement for European nationals. So immigration just wasn't something that businesses or organisations needed to previously think about when recruiting European nationals, but it is now, I'm afraid. So in terms of the new immigration system, there have been some fundamental changes, but really it's just built on the architecture of the old system. So much of the bones, much of those, they remain the same, but there have been some significant changes, and those changes do make overseas recruitment overall more attractive and more achievable. A few of those changes, so there's no longer a requirement to advertise to the resident labour market. And what that means for businesses is that you can choose whoever is the best candidate for your role, regardless of nationality and visa status. If they require a visa, then you would be sponsoring them into that role. You no longer need to give preference to a person who's already resident in the United Kingdom. There used to be a cap on visa numbers. That's been suspended, so there's no longer a limit on visas which can be issued. And then significantly, really to sort of incorporate and allow for the loss of free movement, a great many more professions are now included in the immigration system, and they have been included by a reduction in the skill level. So we used to need to be at graduate level. We can now recruit into A-level level roles, and the Home Office provides us with a long list of occupations which are considered to be at A-level or above, and therefore considered to be of a sufficient skill level to be available for sponsorship under the immigration system. Correspondingly, there has been a reduction in the minimum salary thresholds. So we now look at minimums of 25,600 all the way down to 20,480. But roles do still need to be paid at what's called the going rate for the role, and the Home Office gives us the definitions in terms of going rates. Now, undoubtedly, this does make immigration and recruitment of overseas nationals easier and more straightforward, but it isn't, of course, a substitute for what we had before, which was free movement. I'm going to move on now to an issue that I know comes up for lots and lots of businesses. So this is just thinking about, well, what do I do about my current European national workforce, if anything? Do I need to be worried? Is there anything new or different that I need to do, particularly around right to work? And what about new European nationals who are entering the United Kingdom? Well, right now we're in this period, the grace period. And so for our existing European nationals, and in the context of right to work, nothing has changed and nothing will change until the 1st of July 2021, when we reach the end of the grace period. But it's important, I think, to recognise that European nationals going forward will need permission to work. That permission might be a visa, or it might be leave to enter, or leave to remain, or indefinite leave to remain. So it's important to kind of be of the mindset that that there will be no European nationals, save for British and Irish nationals, who will not need some form of permission. Now, for European nationals who were resident prior to the end of transition, so prior to 31st of December 2020, they will secure that permission. If they've not already done so, they'll secure it on the EU settlement scheme, and they have until the end of the grace period, so the 30th of June, to secure their limited or indefinite leave to remain, and that will be their permission to work. For European nationals who were not prior residents, so who've arrived from the 1st of January, technically they all need a visa or leave to enter to work. So that might be that they have a work visa, so they're sponsored, or it might be that they have a different type of visa, such, for example, as a spouse visa, which gives them permission to work. So you might be thinking, well, that sounds like a bit of a headache from my point of view as an employer, because what do I do? Do I need to determine when somebody entered the UK? Do I need to establish whether they're a pre-Brexit, post-Brexit resident? Well, the answer is no. At this stage, you don't need to determine when somebody entered the UK, because right to work guidance will not change. So we're in this really unusual position of European nationals, say if they arrived after 1st of January, needing a visa to have permission to work, but employers not needing to check that visa. And this really is intended to make life easier for employers, so that you're not having to make these difficult decisions about what evidence you need, and we're not facing a sort of cliff edge in terms of right to work status checks. But it does mean that you'll need to prepare for changes to right to work, which will come in readiness for the end of the grace period on the 1st of July. And we had guidance issued by the Home Office at the end of last week, which indicated that while there's no change to right to work, and importantly, you will not need to retrospectively review or check the right to work of any European nationals that you've recruited during this period, the Home Office does acknowledge that employers may wish to review and check, just to establish that their workforce is in fact working lawfully in the United Kingdom, and that you don't have an illegal working situation brewing. Now, the important thing to remember there is that if you are asking people for status of their right to work, and that request is sort of outside right to work guidance. There's no strict requirement for you to ask for it. Then any request has to be on a voluntary basis. You can't mandate that a person's employment is contingent on them providing you with evidence. And you must act in a non-discriminatory manner. So typically that would mean not identifying people on the basis of nationality, but any communications going out being sent to the whole workforce. Okay, so yeah, headlines in terms of right to work is no change now, but be ready for changes on the 1st of July, and we'll keep you posted on those. So just a couple of other elements that I think are relevant to the employers of European nationals. First is, if you haven't come across frontier worker permits, they're quite a handy new little scheme that apply to people who live in Europe but work in the UK. And if you have anybody in this situation, it's well worth advising them to apply for a frontier worker permit. They're very, very straightforward, and they will just give that person ongoing permission to continue to work in that way. And then my final point is around business visitors. So in the deal, the Christmas Eve deal, the TCA, there was very, very little provision on immigration. It was a hotly debated topic, but essentially the proposals that were put forward just looked and felt too much like free movement, and the UK government had stepped away from free movement and wasn't going to step anywhere close to it. So the only provision that we've got within the deal is for business visitors, and it is a helpful provision, particularly if you're working, say, with European clients, European suppliers, or if you have entities overseas in Europe and you might need senior management teams to be able to come to the UK to meet with clients, or to attend training, or to give briefings, or to attend meetings. These provisions cover all of that and essentially allow for visa-free entry both ways, reciprocal arrangements, Europe to the UK, UK to Europe, for a period of 90 days in any 180-day period. And that will cover most sort of in business activities that you would anticipate needing to undertake if you're a UK business doing business in Europe, or vice versa. So, you know, all these matters will be covered in much more detail in our global mobility session on Friday, and I'll be joined then by one of our tax experts who'll be able to talk through any of the sort of tax implications arising from having, say, people working in Europe but for a UK based entity. But for the time being, I'm going to hand straight back to Sal Jenkins, and she'll just be coordinating the Q&A session. So all that leaves for me to say now is just thank you for attending today, and I hope that you're able to pick up on any of the subjects that we've covered in some of our later sessions this week. Thank you, and over to you, Sal.
Thanks, Emma. Thank you all. That was all very interesting. We've got a raft of questions for everybody, so I'm going to act with ultimate fairness and just ask one of everybody each, if I may. So Iain, if I come to you first, one of our attendees has said they've heard about blockchain helping to reduce the risk of supply chain failures. How does that work?
Oh, wow, some very advanced question. Well, I think blockchain can help reduce supply chain failures, and essentially, I mean, a blockchain or any sort of distributed network sort of technology creates supply chain transparency and validation. That's what it's for. I mean, originally in the financial services sector, but there are increasing use cases outside financial services. And I think what blockchain does is creates a greater level of assurance and greater accuracy through multiple points of data corroboration in the supply chain. So in essence, the benefit, I think, to businesses is a massive reduction, possibly even depending upon how good the technology becomes, the elimination of supply chain errors that cost businesses, millions of pounds a year. So a couple of very quick examples. Tesco's horse meat scandal. if the meat had been validated through a blockchain system that shows its journey from farm to shelf, would never have happened. Asda are working with IBM at the moment to address issues of food contamination through what they call the blockchain. Blockchain Food Safety Alliance, I think it's called, based on IBM's distributed ledger technology, so IBM's version of blockchain. And I know, De Beers, for example, the diamond merchants have been using or looking at using blockchain solutions to keep conflict diamonds out of the retail system, for example. So, and then you can see other uses, for example, in the construction industry. Now, this is more about payments. So, construction industry, you look at Carillion, and you have trades who are subcontractors of main contractors or subcontractors, and where the main contractor goes bust and the subcontractors haven't got paid. You can see a use of blockchain, for example, that each piece of work is put into a block. When that block is and the blockchain is pre-funded by the employer, by the client, the customer, and when each block is completed and that completion is validated, that subcontractor gets paid even if the main contractor has gone bust, because it doesn't rely on a flow of funds down from the client to the main contractor to the subcontractor to the subcontractor, for example. Sorry, that's probably
that's great. I put you right on the spot. So. Lindsey, a question for you, I think. Has the Brussels Convention now disappeared for the UK?
Yeah, the short answer is effectively yes, save for where you've already issued court proceedings and you did that before the 1st of January 2021. For anyone who doesn't know what the Brussels regime is, it's a international convention which is normally known as Brussels Recast, and that was a very helpful regime which provided for the cross-EU recognition and enforcement of contractual jurisdiction clauses and also of court judgments. It no longer applies as between the EU and the UK. It continues to apply between all of the other EU member states. It's been replaced by something called the Hague Convention. It's broadly similar in idea, although it gives to some extent some way to plugging the gap that's going to be left by the disappearance of Brussels Recast, but it isn't as comprehensive. And when we speak about this on Thursday, I'll be taking you through some of the pitfalls with Hague and some of the areas that it doesn't quite cover off that would have been covered previously under Brussels.
Lovely, thank you. And Luke, a quick one for you. Do you think we will implement the new e-privacy regulations which have been mooted?
Thanks very much, Sally. Yeah, that's an interesting question. I mean, I spoke, for those who actually don't know much about this particular piece of legislation, or basically we have been operating under the Privacy Directive in the past, along with the rest of the European Union, and this particular piece of legislation regulates a number of things, but I suppose most chiefly, most businesses, regulates the sending of unsolicited electronic direct marketing to individuals, and it's deemed that this was actually supposed to have been replaced around about the same time as GDPR, and for the same kind of reasons that GDPR was introduced, that it was actually the current directive for which our national legislation derives is no longer deemed really fit for purpose or sufficiently protective. So there's the new draft e-privacy regulation is now going through the works, but it's been going through the works extremely slowly, real snail-paced stuff, because it's actually deemed to be quite problematic and difficult for businesses. So the draft's undergone a number of different versions. It's currently sitting with the Portuguese presidency, so that Portugal will be introducing some proposed changes to it. It then remains to be seen how basically those changes fly, whether they can sort of be approved and then moved on. So I did say at the outset of this talk that we had committed ourselves to continuation of protection in relation to unsolicited marketing, and I did say at the outset of the call that we remain, I think, committed to high standards and a certain degree of alignment for the foreseeable future with the EU. I therefore think, particularly if it's sort of watered down a bit more, I think it's more likely than not that we would implement this regulation into our own national legislation or something substantially equivalent to it, in order to pursue, these concepts of alignment and high standards. And if assuming we get an adequacy decision, it will hopefully help us keep that adequacy decision. But certainly very much worth keeping an eye on this as well, because it could be potentially a bit more restrictive for businesses than the current sort of directive-based legislation has been over the last few years.
Great, thank you. And Simon, a quick one for you. One of our clients is worried. They say it sounds expensive to have to register trademarks and designs in the EU and the UK. Is there anything we can do to help them with that or to reduce that cost?
Yes, I think so. Probably most important is to consider what you need, and whether, particularly in the case of designs, you can rely on unregistered rights, which we'll talk more about in the webinar on the 1st of March. On trademarks, it may be that a different approach to filing could help. It's probably a really good time to review what rights you have and what you'll need for the future.
Okay, lovely, thank you. And Emma, just very quickly, one last one for you. I did promise to get around you all. One client says, our business expects to recruit from Europe in the coming year. Is there anything we need to do now in preparation?
Yeah, so I'll keep my answer brief. I'm conscious of time. The most important thing to be thinking about now, if you are minded to recruit from Europe, is to secure your sponsor license. Once it's in place, it's valid for 4 years and easily extendable. So it's well worth doing that front-loaded work now and then being able to be quick-footed and nimble as soon as you find the right candidate that you want to fill the vacancy that you have.
Lovely, thank you. Thank you. I'm going to take the opportunity to thank all of you for joining us this morning, and a big thank you to our expert panel for their thoughts and insights today. As they've mentioned, there are in-depth sessions on each of these topics if you'd like further information, and we will be following up with you all in the next few days with any questions that weren't answered here, and we'll send a recording of the webinar for you as well. We hope to see you on the upcoming sessions. Finally, a special thank you to Tom Williams and my team for all his hard work in putting this together. Thank you once again for joining us. Please keep safe and stay well.